Well, good afternoon or good morning, depending on where you are. Welcome to today's presentation, Privacy Lawsuits Are Changing. Is Your Compliance Program Keeping Up? My name is Josh Stevens. I'm a partner here at McMurray and Shuster, joined by my partner, Nick Whisler. Before we get started, just a couple housekeeping items. This presentation is being recorded and will be available on our website either later today or tomorrow. So if you have to drop early and you want to catch the full version later, that's where you'll go to find it. If you have questions during today's presentation, please put them in the Q&A box. Those will pop up for us. We may take them during or we may hold them until the end, but that is where you can submit your questions. And as always, if you have questions that you think of after the presentation, don't hesitate to reach out. As I mentioned, Nick and I are partners here at the firm. These are our mugs you get to stare at for the next hour. So apologies on that. Real quick disclaimer, because we are lawyers, we love disclaimers. Remember that we are talking today at a high level from an educational perspective. This is not legal advice. Facts really, really matter in everything that we're going to be talking about. So definitely consult with your counsel before taking any actions based on what we discuss. We've got a lot of ground to cover today. As you see on the agenda, we're going to talk about some recent privacy developments. Then we're going to go to some areas of recent litigation with wiretapping, eavesdropping claims, and claims under the Vehicle Privacy Protection Act. We're then going to shift over to some enforcement actions, the Sephora action from the California AG under the CCPA, as well as an enforcement action by the FTC against Twitter, and a geolocation opinion from Canadian regulators under PIPIT, and some insights that may provide for US privacy law. And we'll wrap up with some TCPA and other assorted litigation trends for calls and texts. And with that, I'm going to turn it over to Nick to get us started with some recent privacy developments.
So yeah, I think the focus of our session today really is about the enforcement, both the class action and regulatory actions. But before that, there have been a number of privacy developments recently that are just worth mentioning very quickly. So many of you may be aware that the FTC had issued advanced notice of proposed rulemaking, and as part of that, they solicited comments on a number of different issues and topics. And just recently, they extended the deadline for those comments to November 21st. So anybody interested in filing comments, you do have a little bit longer to do that now than you had previously. Also, Colorado is one of the states with a forthcoming privacy law. It recently released draft regulations. So those are out there. There are a number of slight differences between how they're thinking about things and how California is. So that's an interesting aspect, something to pay attention to for companies doing business nationwide. And then speaking of California, they actually just released the second draft of their CPRA regulations. They did so in advance of what was supposed to be a board meeting last week that got postponed to this week, Friday and Saturday. And they've also scheduled another one for the following week on November 4th. So quite a bit going on in California. Super high level takeaway is that they removed a few of the more onerous requirements from draft 1 to draft 2. There still are some things in there that are either concerning or onerous, or just things that companies will have to figure out how to deal with. There still are some difficulties there, but again, the changes were largely favorable from draft 1 to draft 2. So with all of that, really kind of getting into the meat of what we're talking about here today, a number of things we wanted to talk about, right? So we know that the plaintiff's bar had focused pretty extensively on TCPA litigation. Yes, there was FDCPA for debt collection. Yes, there was Fair Credit Reporting Act lawsuits, call recording lawsuits, a number of different things, but TCPA was the bread and butter of the plaintiff's bar for a long, long time. With the interpretations related to what's an auto dialer under the TCPA, making it more difficult, they are now shifting their focus. So they're thinking about other ways to go after companies for consumer protection and privacy types of issues. This concept here of using the existing wiretapping and eavesdropping laws, but in a new context, instead of for call recordings, they're now bringing lawsuits related to online technologies. This has been going on for a couple of years now, but there have been some recent developments that kind of shape things. There's still a bunch of unanswered questions to be thinking about. And so we just wanted to make sure that everybody kind of understands what's going on. You'll see on the slide deck here that the states that we had seen these traditionally in were California, Florida, Pennsylvania. I think those are still where maybe the bulk of them are coming. I have seen them in Illinois, Washington, other states. So these are certainly not the only states, but they are some of the more prominent states. And so really what the issue is, there's a couple of them actually, but number one, sites that are using session replay tools to track users' movements around the site may or may not be paired with some type of keylogger so that they can see the user typing on the website before they would actually submit a form or anything like that. And so the argument is that these technologies are essentially capturing communications between the user and the website operator, and that if you're doing this without consent, it violates the California Information Privacy Act or similar types of state laws in other states. And I mentioned that the applicability in this context is not entirely clear. We have had a bunch of case law in California, for example, and the issues have been whether the technology that's recording this is a participant to the conversation, because if so, then it wouldn't be a violation. There's been some questions about whether the technologies are actually recording the contents of the communication or not. So those are still open questions. The Ninth Circuit recently invalidated a prior lower court decision. And basically what happened was they said, well, even if this was applicable, you provided consent by submitting the form. And that form, you agree to the terms, you agree to the privacy policy. They outlined this type of feature and use, therefore you consented. The Ninth Circuit said you can't get consent after the fact. You know, you had to have consent before you would use the technology. They didn't really opine on, again, the applicability in the specific context and whether the law attaches. So again, some open questions there, but it is a risk, and many companies are dealing with lawsuits stemming from this issue. Another interesting area is they're also now bringing lawsuits against website operators that have chat features. So user gets on, they start communicating with the website operator via chat. They are recording that interaction. They're saving the transcripts of the interaction, and they're alleging that doing that without consent to do that is also violating these laws. So a couple of different contexts. In addition to California, I mentioned some of these other states. In Florida and Pennsylvania, the case law had traditionally been quite favorable, saying that these laws didn't really apply in this context. Very recently, the Third Circuit, though, overturned a lower court decision related to the Pennsylvania law. It was a case involving Harriet Carter gifts, and they said that the law applied. They acknowledged that in Pennsylvania, implied consent was sufficient. The defendant had argued that, well, this was covered in our privacy policy. They didn't really address that issue. They said whether it was or wasn't covered, number one, and number two, whether in the privacy policy itself is sufficient notice to get implied consent were issues for the lower court to have to work through. So they didn't opine on that. In terms of, what are we doing about this? I think the safest thing by far is to have an affirmative opt-in. So this might look like, some type of cookie-like banner that describes these types of practices, requires them to click an accept button or something like that. Perhaps maybe getting them to accept privacy policy or terms where this is disclosed behind that might be the second best option. And then, the issue of implied consent, some type of more prominent notice, some type of just by using the site you agree type of thing might be okay. I think we still have some questions about whether that's enough in California to the extent that the law does apply in this context. So There are a number of different things to be thinking about. I think your risk profile is going to probably impact what your strategy is here, but I do think some type of consent express would be best, implied would be next best, is something that you should be thinking about and figuring out how you can roll out on your website. I will just mention real quickly too, for those of you that maybe aren't sure whether you have those types of technologies embedded in your website, hopefully your IT and marketing teams can help with that. If not, there are some imperfect but publicly available tools you can use to scan your website. So it'll give you an indication of what others might see on your website by doing their own scans. So there's one called the Blacklight. It's from an organization called the Markup. But there are others that you can use as well, but it's a good tool to help at least facilitate the discussion. But you really should have an idea of a definitive list of everything that's operating on your site behind the scenes.
Yeah, and probably should have the definitive list, not just for the eavesdropping claims, but also for privacy compliance, right? As we're coming up on January 1 and all these new state privacy laws, that list would be helpful for that work as well. So as Nick mentioned, right, the plaintiff's bar is looking for new avenues to bring claims. And another one that's become very popular this year are claims under the Video Privacy Protection Act, which is a little known statute, or at least little known up until probably the last 12 months, that was passed in 1988 to protect the confidentiality of video rentals. And for those of you who may be politics nerds, you may remember the failed nomination of Robert Bork to the Supreme Court during the Reagan administration. He had made, just because it's interesting, he had made some claims during the hearings about how Americans didn't really have privacy rights unless they were granted to them by a statute. And so a Washington tabloid went and got his list of video rentals and published them. And of course, the quickest way to get Congress to act is to embarrass someone in Congress. And so we got this law back during the era of VHS and Betamax. But what's happened now is the concept of a videotape service provider, which, contrary to its name, also has some broad language around someone who provides similar audio or video media. Courts are starting to view that as also applying to online sources. So for example, there was a case against Hulu several years ago, and the court allowed the VPPA to cover the type of service that Hulu provides. And what the law prohibits is a videotape service provider from knowingly disclosing personally identifiable information concerning any consumer of that provider. And this term consumer basically says a renter, purchaser, or subscriber of audio video content. And these terms are not defined in the statute. If you actually pull the statute, it's very short. A lot of the terms in it are not defined. And so while renter and purchaser are just in common terms pretty well understood, someone needs to be paying money to obtain that audio video content, subscriber is a little softer. And so that's where we've been seeing a lot of these claims come up is under this concept of a subscriber. And so if you're a website operator and let's say you're not Netflix or Hulu, where it's very clear that you have subscribers who are paying money. Let's say you've got free videos, maybe some tutorials on your website about, I don't know, privacy compliance. And if we use our website as an example, and people can come and they can view those videos, you get into this interesting analysis of whether that person is a subscriber or not. Do they create a login? Do they give you their email to get access? Is there a button to subscribe, like on YouTube, where everyone tells you, right? Smash that subscribe button when you watch a YouTube video. And so we see this concept of subscriber having a little more leeway than renter or purchaser. The other angle on this has to do with the definition of personally identifiable information. So we've been talking a lot in recent webinars about this broad concept of personal information under California's privacy law. The definition under VPPA is a bit different. Personally identifiable information is information that identifies a person as having requested or obtained specific video materials or services from a videotape service provider. So here's where companies have been getting in trouble. Let's go back to that example of the website with the privacy tutorial videos. And unlike our website, let's say that website has a Facebook pixel built in that alerts Facebook when a user watches a video on that site. So Facebook is a third party. They're not the provider of that video, but now that video provider has arguably disclosed to Facebook that this user has watched this video. The debate and the argument that's been happening in a lot of these cases is about whether the information that's obtained by something like a Facebook pixel actually identifies a person, or is it too anonymized, so it actually doesn't do that. But the risk here is quite high, and we've seen some pretty aggressive cases being brought here, because you can get up to $2,500 in statutory damages per violation, plus potentially punitive damages and attorney's fees. So much like the TCPA, there's a strong financial incentive to bring cases, even if they're maybe a little weak, in order to extract a bounty. So what can you do about this? Well, there's a couple questions that I like to think about in terms of risk mitigation. The first is to ask, do you provide videos on your website? Or I'll extend that as well to a mobile app, right? Is there a vehicle through which you're providing video content? Then we should talk about, do consumers rent, purchase, or subscribe to those videos? As I mentioned, if there's financial compensation, rent or purchase is likely there. If there's not financial compensation, then it's a much more onerous analysis to find the strength of whether or not that consumer is a subscriber. And then ask, do you allow third parties to learn what videos your consumers watch? So going back to Nick's point about coming up with that list of third-party tools that may be tracking conversations, similarly, third-party tools that may be learning what visitors are watching videos or coming to pages of the website where videos are present. And then when we go through those three steps, then we need to ask, based on the above, should you get consent from those consumers, or should you stop allowing those third parties to learn what those consumers watch, or a combination of both, right? So maybe you've got an analytics provider that you want to track because that's an important metric for you, but you don't want to have Facebook track because that may look bad to a consumer when you go to get that consent. And so every brand is going to have to make its own decisions as to where it feels comfortable on this. But the key point is, if you offer video content on your website, you need to have this front of mind and be working with counsel to figure out ways to mitigate your risk. And so on that privacy front, Nick, what's going on with CCPA?
A lot. I think a lot of people probably saw the headlines with the first ever CCPA fine, which involves Sephora. It was a $1.2 million fine. We'll get into kind of the mechanics of that and what they got in trouble for. But I think what's important to understand is Sephora was the one who got fined, and mainly because they didn't fix the issues within the 30-day right to cure period. So they have been doing enforcement sweeps. They've been looking into several different issues, which we'll go through here. The key is many of the companies that were notified of non-compliance were able to rectify the situation and get into compliance within that 30-day period and therefore avoid a fine. That right to cure period ends on January 1 of next year. So while we can learn, they publish a website that has a generic summary of all of the different enforcement actions that they've engaged in, or at least many of them. They just identify the industry that the company was in, what the issue was, and then how they rectified it. So we can learn from kind of what's been going on. We don't have all the details. The investigations aren't public, but we can learn from what they publish. What are they looking at? What are companies getting in trouble for? How do they fix it? And that can help guide our compliance strategy. So with that as background, in terms of substance, I think the number one takeaway is that they are looking at this issue of a sale, both online and offline, and making sure that you're complying in many respects. So number one, do you have a do not sell my personal information link at the bottom of your website? Number two, do you accurately describe in your privacy policy that you're selling information and that people can opt out? And then number three, which was part of the Sephora issue, was if you have these third-party integrations in your website. So you have a Facebook pixel, you've got some Google products, you've got, there's many third parties that have these types of tags and other technologies where they are collecting data from your site. If you have that, and they are not bound by contract to act solely as your service provider, meaning they're only going to use the data they collect for purposes of providing services to you, not for other advertisers, not for themselves. If that contract is not in place, then by giving them access to your site and letting them collect data, that is a sale. This was an issue that we had highlighted at the beginning of CCPA. I think many companies try to take the position that it's not a sale, but the California AG has expressly said otherwise. So what that means is you have to accept and honor opt-outs. And there's two mandatory ways in which you have to do that. Number one is you have to have a form that somebody can fill out, providing their information, saying that they would like to opt out of sales. And again, with offline data, that's a pretty easy thing. You maybe put a flag in your database next to that consumer saying, they've opted out of sales, and anytime you're sharing data offline, you can remove their information from the feed that you're providing. Online, though, what that means is that your form is going to have to opt these people out of these third-party integrations, again, unless you have service provider restrictions in place. And so, oftentimes that'll work in tandem with some type of consent or cookie management tool. So by submitting the form, it's going to tell the tool like, hey, opt them out of targeting cookies, opt them out of perhaps analytics or functional cookies, depending on what integrations you have and what contract provisions you might have in place. And so that's one way. The other way that people can opt out is they can use a browser-based kind of user privacy preference signal. And the one that the AG has expressly authorized, not as the only one, but as an example of one, is called global privacy control. And so Sephora and many other websites were not set up such that when the user, let's say I'm the user, I have set up global privacy control so that it tells every website that I visit, I don't want you to sell my information. I then go to your website. These websites were not set up to acknowledge and accept and process that request, and therefore they were violating the CCPA. So this is an issue that, again, with Sephora, I think has gotten heightened attention. I think people are really moving on this now. I think because of the right to cure period ending, I think the risk is certainly going to increase as we get into 2023. But again, I think knowing with third-party integrations, knowing which ones are used for targeted advertising. Right now, we're talking about sales. Under CPRA, there's another concept called sharing, which is basically disclosing data for targeted advertising purposes. And you have to honor an opt-out in that context. A contractual restriction on these third parties to only use the data for you does not work, because they cannot be a service provider if they provide targeted advertising services. So that will require an opt-out no matter what. And then for all the analytics and other types of companies, you can either honor an opt-out or make sure that your contract imposes service provider restrictions on them. Those will be your two options. So that's I think far and away the number one thing that we're seeing in terms of enforcement, but it's not the only thing. Other issues that we've seen are defective privacy policies. So they are missing information that's required by the CCPA. They are not adequately describing people's privacy rights. Maybe they didn't view these third-party integrations as a sale, maybe it's something else. They are using confusing language, or just they're really unclear about what it is that they're doing. Those are the types of things that we're seeing there. In terms of privacy request methods, maybe you're making them click 4 or 5 different buttons to actually get to the form where they submit their request, right? It should be just one link, goes to the form, they can fill it out. This could be a deletion request. This could be a right to know request where they ask what information you have about them. This could be an opt-out of sale, but it should be pretty easy for them to submit these requests, and companies that have made it more difficult have gotten into trouble, or at least been contacted and notified of their deficiency. Any companies that are offering loyalty programs, I'll just point this out. Many of them, in fact, probably most, are deemed financial incentives under the law, and there are certain rules that you have to meet in order to avoid their anti-discrimination requirements. And primarily what that means is certain notices and an opt-in process for that. So just know if you have a loyalty program, you should be thinking about, is it a financial incentive? And if so, are we complying with these requirements? There has been some enforcement around that we've seen. Notice at collection, I think this is actually a really interesting topic. So many companies understood that at the point of collection, you were supposed to disclose certain things. It started off being categories of PI and then how you use it, and they just keep adding to the list. They make clear, though, that linking people to the top of your privacy policy is not enough. So you have to either create a dedicated section within your privacy policy that contains all of these disclosures. And again, the list is growing quite significantly, and the draft CPRA regulations are contemplating additional things to be included in there. And so you either have to almost have a privacy policy that, because of this section, becomes a little bit duplicative, or you need to be thinking about creating a standalone notice. I've seen people refer to it as like a California privacy notice or something like that, and then link to that. So let's say you have got an online form, you are collecting people's information, you would have some type of language that would link to probably your California notice and your privacy policy. Within your California notice, you provide just the information that's required in that notice, and then refer them to the privacy policy for more information. So again, it's kind of an interesting shift. We had seen when CCPA came out, a lot of people had a privacy policy and a California privacy policy. It's kind of similar to that, but it's not really a policy. You don't really have to necessarily go through all of their rights. You have to cover some of them, and you have to refer them to the privacy policy to get the rest. But this concept of a California specific notice is something that you should be thinking about either as a standalone notice or as part of your privacy policy. But again, you can't just link your privacy policy. That's not going to be enough. And their enforcement activities make clear that that's something that they actually care about. The last one that I think is worth talking about, and these aren't the only ones that I think were most common and interesting for purposes of this discussion. They do care about service provider contracts. So to the extent that you're using a service provider, whether it's somebody in terms of your website or your mobile app, maybe it's offline, whatever, if you're providing personal information to them for them to perform services for you, you need to make sure that contract complies with the CCPA and the CPRA, which will be coming into effect soon. And there are also contract requirements under Virginia, Colorado, and these other laws that have adopted, these other states that have adopted privacy laws. So really important to make sure your service provider contracts are buttoned up. This has not been an area of CCPA enforcement, but just because we're talking about contracts, one thing to keep on your radar is that CPRA, which will come into effect soon, requires you to have contracts with anybody that's providing you data, or any companies to which you're providing personal information, whether it's a sale or a sharing or just a disclosure for some other purpose. So these are people that are not necessarily providing services to you, but you're disclosing personal information to them, that contract must have specific things in place, including limitations or specific purposes for which they're allowed to use that information. And your data sources, if that contract doesn't have these things in place, the regulations say that you can't use the data that they provide. So as a business, you are incentivized to make sure that both your supplier contract and any other downstream contracts you have in terms of sharing personal information all comply with these requirements. And if they don't, there's significant legal implications of that.
Yeah, and we've been talking so much about states here recently. It's been easy to forget that the Federal Trade Commission is still out there in the privacy realm. And we got a good reminder of that back in May with a settlement between Twitter and the FTC and DOJ. So essentially what happened is, at least as the FTC's alleged, that Twitter disclosed to users that it would use their contact information for account security purposes. And so this was a disclosure that was given when users put in their information, but they failed to disclose that they would then use it for targeted ads, which is actually what they did. And so this is kind of a reminder that under the FTC's UDAP jurisdiction, right, unfair, deceptive acts and practices, if you tell a consumer X and then you go and do Y, that's often going to be deceptive. And so the result of this is Twitter paid a $150 million penalty, but more importantly, they were required to implement a comprehensive privacy program. It's quite detailed, with an independent third-party assessor who will come in and audit their compliance with those requirements and report on that back to the FTC. And we've been seeing this a lot in regulatory enforcement actions around data breaches. But now we're seeing it here in an enforcement action around potentially deceptive conduct with regard to privacy, where it's not just the money you pay, it's now the oversight. It's having a government regulator dictating your privacy program and actually monitoring you to make sure that you are complying. The learning from this is that your disclosures, whether it be in your privacy policy or an upfront disclosure that you're giving to a consumer when you're collecting their information, needs to be accurate and it needs to be comprehensive. So let's take the Twitter example. Perhaps at the time that they first collected this information, they really did think that they were only going to use it for account security purposes. And so at the time that they put that disclosure up, that was their intent. They weren't planning to use it for targeted advertising. But then later, somebody decided, well, let's take this data that we already have and let's use it for this other purpose. Because that purpose wasn't disclosed at the time that the information was collected, then you're running into a situation where consumers were potentially deceived because they were told Twitter was going to use the information for one purpose and not any other purpose, and then Twitter went and used it for this other purpose. So when we think about writing privacy policies, for example, we try to be future-proofed as much as we can. Work with the business to think through not only how are we using the information today, but what could we conceivably plan for using the information in the future? And if writing disclosures at a point of collection where we're saying to the consumer, we're only going to use this specific piece of information for this specific purpose, making sure that there's a way in the back end for that information to be flagged as only being able to be used for that particular purpose. So just as we're approaching January 1 and everybody's thinking about updating privacy policies, updating point of collection disclosures, keep this in mind about both being accurate and comprehensive in your disclosures.
Hey, Josh, one interesting kind of corollary there is these new state laws that are forthcoming, they really focus on that concept of data minimization, right? So you're only supposed to collect, use, disclose personal information for purposes that are compatible with the context in which you're collecting it. The draft regulations under CPRA adopted a very onerous, narrow interpretation of what data minimization is. So it was, if that standard would have been adopted, it would have basically said that you can only use data that for the purposes for which the consumer is providing them, basically. They walked off that a little bit. They are now contemplating that if you disclose additional uses, and as long as those additional disclosed uses aren't incompatible with the context, so it may not be the specific purpose for which they gave the information, but it's at least compatible with the relationship you have with the consumer and the purpose for which you're engaging with them, you can take those additionally disclosed purposes into account for your data minimization analysis. So bottom line, there's more flexibility, but that doesn't mean that you can collect anything and use it for any purpose. And it also highlights what you're talking about, which is making sure that those disclosed purposes are as broad as allowable under this concept of data minimization, right? We can't cross certain lines, but we want to make sure that we are disclosing all of the different potential future uses. Because if you don't do that up front, you have to get consent later to use it for those new purposes, which can be a challenge in and of itself.
Yeah, and especially with how states are likely to view consent, which is actually what I want to talk about next. So good segue there, Nick. So also over the summer, there was an enforcement action out of Canada, the Privacy Commissioner's office up there under the Canadian privacy law, referred to as PIPIT. And for those of you in Ohio or the northern part of the country, you're probably very familiar with Tim Hortons, the wonderful coffee and donut chain. And Tim Hortons has an app, like pretty much every other business. And where they ran afoul of PIPIT is this app collected precise geolocation, so granular information about the user's location, even when the app was closed. So there's, I think we all have used apps where, it's prompted us, hey, do you want to see the restaurant that's closest nearby or something like that, right? But oftentimes we don't think about, is that app potentially tracking us in the background after we've closed it? The app did disclose this tracking in the sense that it was collecting geolocation, but it claimed that it was being used for targeted advertising purposes and analytics, and it used the very generic geolocation consent frameworks that are built into the operating system. So if you have an iOS device, right, you get that pop-up that says allow once, allow while using, never allow, I think is the other option. And so, it's using that tool that's built into the operating system, which doesn't really tell you a lot. It just basically says the app wants to use your geolocation, and then you pick a button. So the Privacy Commissioner's office received some complaints about this. And in their investigation, they found a couple things. One is that there was no legitimate need. So going back to this concept of data minimization, right? And, are you collecting information for a legitimate need? And what the Privacy Commissioner found is there was no legitimate need to collect such vast amounts of sensitive location information, because Tim Hortons, on one hand, while Tim Hortons said they were using it for targeted advertising analytics, they actually didn't really use much of this data. They used some aggregated forms of it for some competitive analysis, but they really didn't use much of the data. But even if they had been using it, what the Privacy Commissioner said is the loss of user privacy was not proportionate to the benefits to Tim Hortons. So it was essentially applying kind of a balancing test of is the benefit to Tim Hortons so great that it warrants tracking people when they don't think they're being tracked, while they're going about their daily lives and maybe going to a religious service or going to a healthcare provider or doing other things that they might want to be private. And the other issue that the privacy commissioner had is that the consent mechanism. So for background, PIPIT requires consent for data collection, but whether that consent is expressed or implied depends on the data being collected. Obviously, precise geolocation, especially tracked over a period of time, is going to be more sensitive, so express consent is likely to be required. So the privacy commissioner found that the consent mechanism they were using, right, that little inbuilt thing, was not appropriate because it didn't fully inform the user of the collection practices, specifically the fact they would be tracked while the app was closed, and the consequences of that collection. So what I just mentioned, right? You're being tracked when you go to a religious service, when you go to a healthcare provider, when you go visit some store that maybe you don't want somebody to know you're visiting, right? Informing people that now Tim Hortons is going to know that. They're going to know all of that. And so what does that mean for you? Now, there was no fine levied, but there was a change in business practices. They agreed on a settlement. Tim Hortons had to delete a lot of this data. They had to purge it. But what this really triggered for us is that this concept of consent, right? So like Nick was just mentioning, getting consent for new uses of personal information that weren't previously disclosed under these new state privacy laws. But also some of these new state privacy laws require that you get consent in order to collect sensitive personal information in the first place. And precise geolocation is often a type of sensitive personal information. For these states that require consent, they've borrowed from GDPR how they talk about consent, that it is freely given, specific, informed, and unambiguous. So I'm going to go through each of those here in just a second. But just to level set on education here, right? GDPR is the General Data Protection Regulation out of Europe. It's been around since 2018. And GDPR has certain requirements related to legal bases for processing personal information. And you have to have one of a certain number of legal bases for every type of data processing you do. One of them can be consent. And so there's a lot out there on what consent means under GDPR. So if these states look to the guidance that has developed over the last few years around the concept of consent under GDPR and bring that over here to the US, it's going to be a pretty onerous standard of consent. Here's why. Let's take each of these elements based on the guidance issued by the European Data Protection Board. Freely given. Freely given means that the consumer cannot suffer any detriment from withholding the consent. So you can't coerce them into giving it to you. You can't withhold a good or service because they won't give consent. Now that's Europe, right? We may have a somewhat different concept of it here in the States, but the idea there is that the consumer isn't being harmed or being denied a benefit by withholding consent. The second point is specific. So you can't bury the consent in a terms of use or some big lengthy privacy policy. It has to be narrow to the specific collection and processing activity that you're going to engage in. And so just putting it in a privacy policy and saying, you agree to our privacy policy doesn't work under GDPR. You typically have to give a just-in-time disclosure or a point of collection disclosure that explains that data collection and processing, which goes to the next point, which is informed. So under GDPR, that direction, that disclosure rather, has to explain what data is being collected, how is it going to be used, to whom is it going to be shared, why is that happening, and what are the potential consequences to the consumer from that? so that the consumer understands the risk to them from the data processing. And then lastly is unambiguous. The consumer has to take an affirmative step to indicate their consent. And the European Data Protection Board guidance says that passive actions like continuing to use a website are not sufficient. Pre-checked boxes are not allowed. The consumer's got to take an active step that unambiguously indicates their consent. So I don't set this out here to scare anyone, but just to give you a sense of how consent is viewed under GDPR and how that's likely to come over to the states or may come over to the states because a number of these new state privacy laws incorporate that GDPR language into their law. And we know regulators like to look at what other regulators do to figure out how they're going to interpret something. So it seems natural that they would probably look at what the European regulators are doing under the same language when interpreting their own state laws. And now that I've sufficiently scared everyone, Nick, you want to talk about some more scary things?
Yeah, to kind of bring things full circle. I mean, we talked at the beginning about this, just the fact that the plaintiff's bar is now looking for new avenues to bring lawsuits, right? This is their cash cow. They had relied upon TCPA and other laws, but extensively. And it's also a kind of a copycat industry. So when they see other firms being successful, they copy what they're doing and they start bringing similar types of claims themselves. So in addition to all the privacy stuff, we've got these kind of marketing / privacy rules that restrict, can you call somebody? Can you text them? If you do, what are the requirements for those campaigns? And so just kind of viewing things and how they're evolving. We know that the auto dialer claims under the TCPA are much more difficult to bring now based on the Supreme Court's decision in the Facebook case and the subsequent application of that in lower courts. We still see them. They're still trying novel ways to say that your phone system or your text platform still qualifies, but they haven't had much success, if any. So what are we seeing instead, right? We're seeing a lot of do not call claims. So this would be any marketing call or text. We're seeing this come up in the context of third-party leads. So you're a business, you're purchasing leads from third parties. They've got a form that somebody's filling out and supposedly consenting to receive these communications. Previously, they would have brought probably both do not call and auto dialer claims. Now they're focusing still on the do not call claim. So this aspect of making sure your third-party lead providers are meeting legal requirements, the consent standards here are a little bit different than what Josh talked about for consent for privacy laws, but they are also very onerous. There's very specific disclosures that you have to give. They do have to take some type of affirmative action to agree. It has to identify the specific seller that will be contacting them. So there's a lot of things that go into this. You need to make sure that both your internal forms, but more importantly, in terms of risk and where we see things, are these third-party leads that you're getting. So that's still continuing strong. We're also seeing an increase in the number of internal do not call lawsuits. So any business that is making marketing calls, sending marketing texts, you have to honor opt-outs. They can tell you specifically that they don't want you to contact them anymore, and you have to recognize and honor that. This has been around for a long time. We'd seen a lot of one-off lawsuits. Hey, I told you not to call me, or out that I text, I continue to get them. I want my money, I want to settle, but they were always individual. They were not really successful at bringing these in terms of a class action. There are a lot of pending lawsuits right now where they are trying to do that. And so the idea was that you have systemic issues that you're not accepting and honoring these do not call requests. And we think through business records or through other different things, we can identify who might be a member of the class and therefore recover on a class-wide basis. I still think they have some hurdles to overcome in order to get those certified as class actions. But just know this is an area where the plaintiff's bar is. They are pursuing these types of claims, and they are very interested in seeing if they can make new case law. For example, one of the things I've seen recently is they're saying that by terminating service, that terminates an existing business relationship and therefore contemplates essentially a do not call request. You can no longer contact them. I think there's pretty clear-cut guidance from the FCC and from others that that's not the case, but just know that that's a theory that they're still trying to pursue right now. A more recent issue that just came up is there was a court opinion holding that any cell phone numbers that are on the National Do Not Call Registry are presumptively residential. And that matters because the do not call laws apply to calls to residential numbers. So we know that you're allowed to put a cell phone number on the list. But by being presumptively residential and by requiring the defendant in a lawsuit the burden of proof to overcome that, this now impacts any type of business-to-business campaign that you're running that involves calls to cell phones. We know people use cell phones a lot for business these days. We know that they may provide another company a cell phone number. We know that lists that are purchased that are business numbers might include cell phones. And so any type of B2B campaign that you're running that involves calls to cell phones, those people might use them for both business and personal purposes. And the opinion sets forth a bunch of different factors that would weigh into this. But the point being, you now might be dealing with a lawsuit. If you don't have a valid exemption, you don't have consent, or you don't have a relationship with that call recipient, you may now be defending against do not call claims because the number's on the do not call registry, even if you're contacting them for purposes of a business-to-business transaction. Pre-recorded message claims, we're still seeing these. This has been around for a long time. Anybody sending pre-recorded messages, there's certain consent requirements, depends on the type of message, marketing versus non-marketing, but those are continuing. Really no change there. I have seen some interesting claims recently that a text message qualifies as a pre-recorded message. The case law that I've seen on that is very limited. One or two opinions was they either rejected the claim or they're very skeptical of the claims. So I don't think that those would gain much traction, but it is something that we've seen. Two other things real quickly as we're starting to wrap up in terms of time. We're also seeing lawsuits under federal and state laws related to things that are a little bit more kind of ticky-tacky. So what time of day you can call. There are rules around, federally it's 8 a.m. to 9 p.m. for marketing calls. And there's also rules for like collection calls and other types of things. So, any type of campaigns that you're running, you need to make sure you're complying with those. States have different variants of that. It might be earlier to cut off calls at the end of the day. They might not permit calls until later in the morning. So those are things to be thinking about. I think the one that is the most interesting development relates to disclosures. So the reason the TCPA covers text messages is because they deemed a text to be a call. So all of the rules that apply to calls also apply to text messages. And when sending a marketing text or making a marketing call, you are required to make certain disclosures. That has to include the individual's name, the company's name, the purpose of the communication, and at some point a phone number or address. That doesn't necessarily have to be at the beginning like the other ones, but that has to be there at some point. So we are now seeing lawsuits against companies for sending text messages that do not include an individual's name. So you probably have signed up for or received text messages from various different businesses, perhaps they're marketing, and they often just start with the company's name and they have some message about a promotion that they're running or some other information that they want you to know about, but they don't have an individual's name in the text. Because quite frankly, you're just loading up a list, you're selecting all the people that you want to receive it, and then you're blasting it out. It's not like a specific back and forth texting conversation. Those do exist, but most of these broad campaigns are not run in that manner. So it's a really interesting issue, and Josh and I have had conversations about this, and I've had conversations with others. I mean, the concern with adding an individual's name in my mind is it's a little bit deceptive. It almost seems like if I put my name in the text, it seems like it's coming from me when really it's just a system generated text. Somebody probably had to create the campaign and select the messaging and all of that. But at the end of the day, it's the system that's sending the text. So it seems like a little bit deceptive to do that. However, there are a lot of defenses against deception claims. You could implement certain measures. Maybe it's the person that creates the campaign, maybe it's whatever. You can, the fact that you're doing this to comply with a legal requirement, I think would weigh in. So in my mind, although I don't love it, I think it's a little bit misleading. I am more concerned about TCPA lawsuits that are just, did you or did you not violate the law? I'm not saying that there's no defenses. There could be standing claims. Do you really have standing that were you actually harmed by the lack of an individual name? I'm not discounting any of those things. But for compliance purposes, we really don't like relying on standing and those types of defenses. We really want to be thinking about things that are going to prevent us from being sued altogether. So something to think about, whether you should be including individual names in text messages. There are states that require both an individual's first and last name on these calls and in these text messages. So there are variants from state to state. Point being here, the plaintiff's bar is moving away from certain types of claims and really pressing the boundaries of other types of claims. I think I kind of glossed over this actually, but in terms of moving away from TCPA auto dialer claims, they are bringing those under state variants. So we know about Florida's mini TCPA, as people like to call it. It's got automated system restrictions on both calls and text messages, requiring written consent that's very onerous, mirrors what the TCPA would require if you used an auto dialer. Oklahoma has a law that becomes effective November 1st. So next week, it has more exemptions, like for banks and publicly traded companies and a bunch of other types of businesses. But to the extent that you're not exempt and you have to comply, there are some specific rules around that. So I think the takeaway here is you really need to make sure that all of your phone and text campaigns are buttoned up, not just from TCPA, but also all the state versions thereof, and be thinking about TCPA more broadly and not just as an auto dialer issue and maybe a pre-recorded or do not call issue. There's these other nuances, some of which we've discussed today, some of which we haven't, but there are these requirements, and failure to comply can lead to compliance issues. So with that, I think we'll wrap up. Josh, do we have any questions?
We do. We have one question. And given we're at time, we probably won't take any more live, but if you all want to email us any questions, we'd be happy to get back to you. The one question we do have is, would you say that the FTC is adopting the GDPR-like consent framework as well? So right now, I would say the answer is no. I think it's more about accuracy and completeness in the disclosures, not so much like an informed consent standard for every type of data collection. But when you look at the questions that they're asking as part of that rulemaking that they're working on, you can definitely see the wheels turning potentially in that direction. So I think it's great to keep an eye on that rulemaking. If you have comments you want to make to it, as Nick said, the comment window is open until I think it's November 21st. Get those comments in so you can start to hopefully massage that rule in a way that you like.
Yeah, and one last comment on the FTC thing, that's going to take a lot of time. This is an advanced notice of proposed rulemaking, so these are just conceptual issues that they want feedback on. They are hosting a privacy conference or forum, I believe, Josh, what's the date? It's in November. It's November 1st.
I don't remember.
So, yeah. So they're just gathering information. Then what they'll do is release an actual notice of proposed rulemaking that has specific proposals, and then they'll open that up to comment. So these are, again, very preliminary. I don't think the FTC will have a definitive privacy rule anytime in the near future. In the meantime, they will use their unfair and deceptive enforcement powers to pursue privacy, like we saw in the Twitter case Josh talked about. And then we also have to think about the states that we've talked about quite a bit as well. So, yeah.
Yep.
All right. Well, thank
you, everyone.
Yeah, thanks for attending. If you have any questions, let us know. And as Josh said earlier, this will be available on the website. So thanks all.
Thank you.